Well, hello and welcome. Disability Law Show. John Scholes, your host once again. This week around, James Fireman is here to answer all your questions. Reaching out, we'll give you different ways to do that. 1-855-821-5900 is the phone number every time. help@disabilityrights.ca. And I want to remind you, website pocketemploymentlawyer.ca. You can go there anytime as well. Absolutely free and anonymous. I know it says employment in there as well, but there is a very robust section on disability law inside pocketemploymentlawyer.ca, so feel free to use that as you wish. And there's also contact at the top right of that website as well. James, lots to get through today, including myths that insurers want you to believe are true. We will get to that a little later on in the show, and some emails as well. But first, the week that was, brother. What's happening with you?
Well, one of the common themes that we have on the show is what is the likelihood that an LTD case is going to go to trial? And the answer is invariably very, very small. So small, in fact, that when a case actually does go to trial, I'm not talking about at our firm, I'm talking about in the province of Ontario, when a case actually does go to trial, it gets a lot of attention. It spreads around the disability legal community very quickly because we want to see if the law has developed in any way. And very recently, there was actually a case that did go to trial in Ontario called Cardaris and Sun Life. You can look it up online. It's free for anybody who's interested. But there are a few things about this case that are interesting that will have an impact on those who are involved in long-term disability cases. Now, what I would say broadly is that there isn't really anything new in this case. What it really does is solidified a lot of what we already did know. So one of the things that the judge who decided this case confirmed is that when you have an opinion from a treating doctor, and that treating doctor is saying that this person is not able to work, that opinion is going to be preferred over the opinion of a doctor hired by an insurance company who hasn't actually even met with the claimant before. Now, that's common sense. I mean, we understood this for a long time, but it's nice to see that in a decision that is going to have precedential value for other cases that follow it. Another thing that was really interesting in this case, though, is that the claimant in this particular case had a mental health issue, had a mental health disability, and even though her psychiatrist was saying that she was not able to return to work, her insurer did not believe her, or at least didn't believe that she wasn't able to work more than the 3 days that she had actually returned. And so because of that, what happened was there was an award for mental distress damages of $10,000 because the claimant in this particular case was found to have a very strong sense of what was right and what was wrong. And I find this to be true with a lot of claimants, that they really understand what is right and what is wrong, and they try and do the right thing in all cases. And this particular individual had tried to do the right thing, had gone to her doctor, had gotten her doctor's support that she wasn't able to work any more than she had been, and even so, the insurer didn't believe her, despite never having actually assessed her in person. And because of that, because she knew that she was doing the right thing, knew that her doctor was saying that she couldn't work, didn't feel like she could work either, and was still being told by this insurance company, oh no, what you're saying isn't true, she felt particularly bad, and because she was already suffering from significant mental health issues, this just added on. It made her situation that much worse. It caused mental distress. And so because of that, the insurer was required to pay an additional amount over and above what they would have required to have paid if they had just paid out the policy normally. The last thing in this case, and I think this is really, really critical, is, you might have picked up on this when I was describing it, John, but she had actually gone back to work. She had gone back to work at 3 days a week, so it was 60% of what she had been doing before. And despite the fact that she'd returned to work at 3 days a week, the court still found that she met the definition of totally disabled under the policy, because she wasn't able to work beyond that. So that is really significant, because people really want to understand, if they start a legal claim, does that mean that I can't go back to work? And the answer very clearly is no. It does not mean that. If you are able to go back to work, you can. And in fact, as long as you have medical clearance to do so, you should.
First question is, though, the treating physician is the treating physician that's seeing her. So this other hired gun by the insurance company hasn't even seen her. They're looking at a paper file, possibly. Why would they ever think that would hold any water against someone who's actually been seeing and physically treating this patient? Why bother?
Well, that's a question that makes more sense when you think about how a normal case proceeds. So it isn't as though the insurer in this case was thinking, oh, well, when this case goes to trial, our hired gun who's never met the claimant is going to hold up against a treating doctor. That's not what they're thinking. What they're thinking is that as long as they get a medical opinion from someone, even as weak as it was in this case, that if they write to the insured, to the claimant, and say, well, we've talked to our doctors and our doctors say that you're able to go back to work, most people aren't going to challenge that, even if their own doctors are telling them that they're not able to return to work. And in fact, experience tells us that the insurers are correct. Most people don't bother challenging when they are presented with a denial letter that says that the insurers have hired doctors that disagree with their treating doctors. Most people just give up in those circumstances. And in doing so, they're really giving up on money that they are entitled to, money that they've been paying premiums for, that is there for situations exactly like they're in. When they become disabled, they have no income coming in. It is a safety net that they own, that they're entitled to, and that they should get the benefit of. And if that is your situation, you should absolutely challenge it.
Now, this particular client is back at work, or was back at work 3 days, so earning some income. And you've talked about before commensurate income, meaning 65% of what your normal pay would be if you're under your disability policy. Would the insurance company look at that and say, well, you're back at 3 days' work. If we do the math, we shouldn't really have to pay you anymore because now you're earning income again, or no?
Well, that's a really good question. So the commensurate income test really comes in after the 2-year mark.
Okay.
After the test goes from your own occupation to any occupation. During those first 2 years, the issue is really whether or not you can do a substantial amount of your pre-disability occupation. And so what the court was saying in this case is that even 3 days a week in these circumstances wasn't sufficient. After the 2-year mark, and the court actually did address that particular point, John, the court said that the amount that she was earning, I think it worked out to actually 73% of her income, that 73% would have satisfied the commensurate income test. So she wasn't entitled to anything beyond the 2-year mark. But up to the 2-year mark, where the long-term disability test relies on whether or not you're able to return to your own occupation, she was still entitled.
Would the insurance company get a financial credit for the 3 days she's working, so she's not, she's not double dipping, is what I'm trying to say? Would she get her pay for the 3 days and full disability claim, or would they get a credit for that?
Yeah, so the way that it typically works is there's something called an all-source maximum, and what that essentially means is there is a higher amount designated in the policy. It's usually a number around 80 or 85%, where you're not allowed to get any income, including everything you're getting from disability and everything that you're getting from other sources, including a return to work. That can't be more than 85%. So if you're working 73%, if you're getting 73% of the income you had before, there's still a 12% gap between the income that you're earning and 85%, which would have to be made up by the insurer, which is significantly less than they would otherwise be on the hook for. So yeah, they do get a significant credit, but they're still required to pay that gap.
Too much knowledge, I can't stump you. I'm going to give up right there. I'm going to move on to an email. help@disabilityrights.ca is the email address. This one, James, comes from Valerie. She says, I just started a new job as a customer service rep when my gallstones got to be too much for me to work. After a year on long-term disability, I tried to go back to work, but ended up in hospital for emergency surgery just hours later. I was then diagnosed with fibromyalgia and went on LTD for a few months, but was cut off because the insurer thought my condition was pre-existing. Are they right?
So pre-existing conditions aren't as big an issue as you might believe. So don't feel as though if you become disabled from something that you had before you were insured, that automatically you're going to be disqualified because it's a pre-existing condition. That's not actually the way that it works. Typically, a pre-existing condition is only an issue during the first, usually it's 1 year, during the first year after you become insured. So if you purchase a new private policy, or let's say you start a new job and you get a new insurance policy there, or even if your employer switches insurers, usually it's only in the first year when you become insured under that policy that a pre-existing condition is at issue. After that year is done, then whether it's pre-existing or not doesn't matter. If you've been there for a year, sometimes it's 6 months, but let's for these purposes say 1 year. After that year is over, it doesn't matter whether it was pre-existing or not, you're still entitled to be covered under the policy. If it does come up during the year, so if you do become disabled in that first year after you start coverage under a new policy, then what happens is you look to, it's usually 3 months before you became insured, but it can vary from policy to policy, so you want to look at the timelines. But let's say it's 3 months. So the insurer is going to get the clinical notes and records from all of your treating doctors for those 3 months before you came insured. And they're going to check to see whether you were treated during those 3 months for anything related to the condition that you became disabled for at some point during that first year. And if you received any treatment during those 3 months before you became insured, whether you got therapy or you went to a doctor, or even if you just filled a prescription for medication that you've been filling for some period of time, that counts as treatment. And the insurer will say that unfortunately you have a pre-existing condition and you're not entitled to benefits. And if they are able to establish that very clearly, that you had the same condition, that you were being treated for the same condition just prior to being insured, and you became disabled from that condition within that 1 year time frame or whatever is set out in the policy, then they'll be correct in saying it's a pre-existing condition. Now, moving to Corey's question, it doesn't sound like that's the case here. Even though the disability seemed to have arisen within that 1 year, from what Corey is telling us, it doesn't sound as though there was any indication that he was suffering or she was suffering from fibromyalgia in the 3 months before coverage started. And unless there is something that clearly shows in the clinical notes and records in the 3 months leading up to coverage that that condition existed and that they were getting treatment for that condition, more importantly, then there's no pre-existing condition. And the exclusion wouldn't apply, and Corey would be entitled to benefits.
Let's take a short break, pal. We'll get right back to it. You want to hang out as well, reach out at his help@disabilityrights.ca. Myths your LTD insurer wants you to believe are true. That is coming right up, so stick around. Disability Law Show continues.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Disability Law Show. James Fireman doing the show this week, and we're going to continue with our topic for the week. James, that is myths your LTD insurer want you to believe are true. Here is number one coming at you. You must appeal the denial of your disability or else you won't get paid.
Yeah, okay. So let's use this as an opportunity to talk about the appeal process.
Yeah, you love this.
This is, one of my bugaboos. It's a topic that comes up virtually every week, so let's talk about it now. The appeal process. This is something that is invented by the insurance companies. It is not something that you're going to find in your policy. If you look in your policy book, if you look at the definitions or the procedures, you won't find anything about appeals in there because it's just not there. Appeals is something that the insurance companies have created to maintain control over the process. And I say that because if you think that by appealing, it goes to some independent body like a judge or an arbitrator, it doesn't. When you appeal, all it does is it sends the information right back, usually to the same person that made the decision in the first place. Usually, it's the very same claims handler. Sometimes it might go to their direct supervisor. And if you appeal 3 or 4 times, they might even have an appeals specialist that might come in and render their opinion on it. But at the end of the day, all of them are being paid by the insurance company, and the insurance company is a corporation. And as a corporation, it has a profit motive for their shareholders. That's fine. We understand that. But you need to understand that they're in business to make money for their shareholders. And the way that they do that is by cutting off or denying claims. And as soon as they have found any justification to cut off or deny your claim, it's going to be incredibly difficult for you to move them off of that. Barring any game-changing information, anything that they don't know and that is so significant that it fundamentally changes the information that they have, they won't change their mind. And even if you have that information, that game-changing information, as often as not, it still won't do anything. Appealing isn't going to get you anywhere. What you need to do is start a legal claim. What that does is it removes control from the insurance company. They're no longer able to make up the rules as they go along. They're no longer in charge of the process. And all of a sudden, as soon as you bring a legal claim, you find, oh, the insurance company is now acting reasonably. They're coming to the table and recognizing that they have an obligation to pay benefits under the policy.
Next one, a myth your LTD insurer wants you to believe are true is this one. When they tell you to go back to work, you've got to go back to work. You're done.
No, that's not at all true. So going back to work is a medical decision. That's not a legal decision. So it's not something that your insurance company should be telling you to do. And it's certainly not even something that your lawyer should be telling you to do. Regardless of what your insurance company says or even your lawyer says, it is a conversation that you need to have with your doctor and your treating medical team. If your doctors are on board, then by all means, you should be going back to work. But if your doctors are telling you that you are not medically fit to return to work, I don't care what the insurance company says. And if you have a lawyer that's telling you something otherwise, then you shouldn't be listening to them either. If your doctors are telling you not to go back to work, that means you shouldn't be going back to work, full stop. Now, if you refuse to go back to work despite the fact that your insurance company is telling you to do so, as long as you have that doctor's opinion, you are going to be in a good position to bring a legal claim if the insurance company makes good on their threat. So yeah, it's true. If you don't go back to work, there's a good chance that your insurer, if they've threatened to do so, will cut off your benefits. But at the very least, you've put yourself in a good position as long as you make sure that whatever your doctor's opinion is regarding your ability to return to work is in your insurer's hands, and that's your responsibility. You have to make sure before that day comes that you have your doctor's opinion on paper, and that piece of paper is in front of your insurance adjuster. So they can't make that decision and then later claim, well, they weren't aware of what your doctors were saying. No, they have to know that. Once they know that, that excuse is no longer available to them.
What if you try to go back with your doctor's blessing, doesn't work out, you're back off work, can you get back on claim?
Well, you can. So most policies have a recurrence clause. So if you try to go back to work and you're not successful, as long as the return to work is less than usually, I think it's 6 months, it can vary policy to policy, but as long as you are not back at work for longer than that recurrence period, then you would be entitled under the policy anyway to go back on long-term disability benefits. But whether or not your insurer is going to honor that is a whole other story. And if they forced you back to work, if they're telling you, well, I don't care what your doctor says, we say that you're ready to go back to work, if they've already done that, you shouldn't by any means believe that if you try and return to work and aren't successful, that your insurer is all of a sudden going to be reasonable and start listening to your doctors. More than likely they will not. But yes, you would at least be entitled under the policy to those benefits, which means that when you bring a legal claim, you'll be in a position to put that in that claim and to recover that as part of that process.
Myth number 3 is this, pal, that you have no choice but to go to the treatment clinic or doctors of your insurer's choosing.
Well, no, that's absolutely untrue. So first and foremost, you have to make sure that you are getting the best medical care and that you're comfortable with the people that are treating you. So if you have a treating doctor or therapist that you are already seeing, your insurance company should never get in between that relationship. If they tell you that they want you to stop seeing this particular therapist or doctor in favor of another one, especially if we're talking about the same area of expertise, then there's no reason you should ever listen to that. As long as the person you are seeing is qualified to provide you the treatment that they're providing you, you get to choose who you are going to see. You do have to get reasonable treatment, but they're not entitled to choose who you're going to see. But think about another scenario, John. Let's say you're in a situation where your doctors or even a doctor for the insurance company has said, well, there are some issues here, but they're not getting treated for this particular issue. They need to see this particular expert. Let's say it's a physiotherapist. Well, the insurer will invariably in that situation say, and guess what? We have this physiotherapist here for you. You can go see them and maybe we'll even pay for it. So if they've made that offer to you, that's great. And you say, well, you know what? I'm actually not going to go to that physiotherapist. I've asked my own doctor for a recommendation and they've suggested this particular physiotherapist and that's who I'm going to see. And by the way, thank you for offering to pay. I assume that you will continue to make that offer for the person that I'm choosing to see. And there really isn't any good reason your insurer can give for not honoring that.
Right.
But here's the thing. The reason that they're choosing the people that they choose is because they know that those people are likely to give them an opinion that's going to help them. Those people are likely to say that, oh, well, after 6 weeks of treatment, magically they've become all better. For a couple of reasons. Number one, it makes them look good. It makes them look like they're effective at their jobs. And number two, because they know that they're getting a big chunk of their business from one source, from this insurance company. If they're asking you to see this therapist or doctor, you better believe that they're also asking dozens, if not hundreds of other people to do the same. And if you have a treatment provider that is getting a large portion of their work from one source, you better believe that whether it's conscious or subconscious, that is going to bleed into their thought process. And that's going to create a bias. Whether it's intentional or not, that bias is going to be there, and you don't want to be on the wrong side of that. So never take who the insurer is suggesting. Always go to your own doctor, ask for a recommendation, and see them. And if you're already seeing someone, keep seeing them as long as you're comfortable with them.
All right, we'll take a short break. Coming up here, if let go from your job, do your benefits continue? We'll tackle that after a short one. 1-855-821-5900. And the email address is help@disabilityrights.ca. Stick around. We're coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. This is a Disability Law Show. Thank you for joining us every week. If you do, good to have you here. James Fireman is the guy answering all the questions, emails, and another resource for you, by the way, is mydisabilityquestions.com. That website you can go to. You can ask your question. James or a member of his team will answer it. There's also a searchable database. You can go through the questions that have already been asked. Maybe one similar, if not exactly like yours, has been answered. If not, leave it there, and it will be answered. Again, mydisabilityquestions.com. James, we'll get to one for today. This one from Anthony. Anthony writes in, says, I'm on LTD with complex inflammatory osteoarthritis affecting many joints and am mentally exhausted. My employer said they can't accommodate me in a different position. I'm a fitness instructor, or offer severance pay. My insurer has sent a letter informing me of a change in definition next year and want me to list all of my work skills. What should I do?
Great question. So thanks, Anthony, for writing in. So the first thing you have to understand is that that's a fairly reasonable and common request, asking you about your functional abilities, what you're able to do. So that's something that you're going to have to comply with. And we typically see this right around the point where you are in the long-term disability process. And what I mean by that is when you're coming up on the 2-year mark, it's a very important stage. At 2 years after you start receiving long-term disability benefits in a standard LTD policy, the definition that's relied on to determine whether or not you're entitled to benefits, it changes. It's called the change of definition date. So for the first 2 years, the test is whether or not you can return to your own occupation. And clearly, your insurer agrees, at least at this point, that you're not able to do the job that you had before you became disabled. But after 2 years, the test gets more difficult. It becomes whether or not you can return to any occupation that you're qualified for by training, education, or experience. And that's where this questionnaire comes in. What they are trying to figure out is, what else are you able to do? And that's quite legitimate. They're entitled to know that information because the test is more difficult, and in order to actually apply that test, you have to be aware of your highest level of education, the past jobs you had and the experience that you had, any additional training that you've had that might qualify you to work in a different field than you were working for before. So I don't really take any issue with them sending it to you, but it's important to be specific when you return it. So, let's say that you did receive some sort of a professional designation in some other area. It's important to make sure that you put the year that you got that in, because if your experience or education or your training is not up to date, then it may not be entirely relevant. And also, of course, even if you have significant education, training, or experience in a different area, if those areas are also going to be similarly affected by your disability as the occupation that you had before you became disabled was, then it's not going to make much difference. So yeah, you have to fill that out. You have to comply with reasonable requests, but make sure you provide all the information possible.
I want to get an email in here before we wrap it up in a few minutes here, James. It is help@disabilityrights.ca. This is Ezzy. Ezzy writes in, says, my brother suffered a brain aneurysm while playing basketball, which led to a stroke. His doctors think that he'll have memory loss and struggle with concentration. He worked as a programmer at an IT company with good health benefits before this happened. His employer sent him a letter saying that they had to replace him and may not have a position for him when he gets better. If they let him go, can his long-term disability be cut off as well?
Well, Ezzy, I really appreciate you writing us on behalf of your brother. And if you're out there and you have a loved one or a friend who is struggling with the long-term disability process, by all means, you can get in touch with us on their behalf. You can keep it confidential. We're happy to provide you with information. Consultations are always 100% free. Now, let me get back to Ezzy's question here. So what Ezzy is saying is that his brother is in danger of losing his job and is already on long-term disability. And really what he wants to understand is what happens if he loses his job. Are his long-term disability benefits going to continue if he's terminated? And the answer is very clearly yes. So that's the good news. Yes, the benefits will continue. The way it works is pretty simple. If you have insurance coverage on the date you become disabled from work, whatever insurer is providing you with benefits on that particular day is stuck. They have to provide you with benefits until you're 65 or are no longer disabled. Whether or not you continue to pay into the long-term disability plan, whether or not you continue to be employed by your employer, whether your employer changes insurers to a different insurer, doesn't matter. If you start with one insurer and you become disabled, they are on the hook until you're 65 or are no longer disabled. So that's the good news. Right. However, what I will say is if your brother is let go, if his employment is terminated at some point before his long-term disability benefits are over, then that's going to have an impact on how much he gets, because anything he receives for termination pay is, under most policies, going to be a set-off. So for however many months he gets severance, that period of time he's more than likely not going to get any additional disability benefits. It's just written into most disability contracts, and that's just the way that it goes. One last point, though, I do want to say on this, and this is something that our friend Terry Corcoran likes to talk about a lot. So even though the policy remains in effect even after you've been terminated, one thing that Terry likes to remind us of is if the insurer is in that situation, if they have an ongoing claim for a insured, especially someone who is with an employer who's no longer paying benefits, or paying premiums, I should say, that insurer has a little extra incentive to try and terminate that claim. They don't like continuing to administer claims for clients for insurance policies that are no longer active. So let's say the employer moves on and hires a different insurance company. Especially in those situations, it's administratively much more expensive for them to continue to manage those claims. In Corey's case, it may not be as much of an issue as long as the employer continues to pay premiums under the same policy.
We're done for another show. Nicely done, sir. And we'll leave you at that. If you want to reach James, a member of the team, 1-855-821-5900. That email address is help@disabilityrights.ca or simply disabilityrights.ca as well. We'll catch you next time on the Disability Law Show.